Police cleared him. No criminal charges. Case closed, at least on the criminal side, within just 2 days of the incident itself. And Alan Ritchson, the actor who plays Jack Reacher, still might end up writing a check because of one specific legal fact almost nobody outside of law school actually understands, and that most coverage of this exact story glossed right past on its way to the next headline. Being cleared criminally and being safe from a lawsuit are two completely different things, decided under two completely different standards of proof, by two completely different legal processes serving two completely different purposes. I am a lawyer, and I want to walk through exactly why a closed police investigation did not close this story, using the actual facts of this specific case as the example, because it is one of the clearest, most public illustrations of this exact legal principle you are likely to see this year. Quick housekeeping. I break down real, newsworthy legal situations using the actual applicable law, not just the headline. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into what actually happened. Here are the facts, as reported consistently across multiple outlets covering the story from the moment it broke. On Sunday, March 22, 2026, Alan Ritchson was riding a motorcycle through his neighborhood in Brentwood, Tennessee, with his children present, part of what by most accounts was an ordinary weekend ride, rather than anything the actor anticipated turning into a legal story. A neighbor, identified as Ronnie Taylor, was reportedly upset about the speed at which Ritchson had been riding through the area, a residential neighborhood where a speeding motorcycle would understandably raise safety concerns among people living there. According to Taylor's own account, given afterward to TMZ, an initial encounter happened on Saturday, where he flipped Ritchson off as the actor rode past, and the confrontation escalated the following day, Sunday, when Taylor approached Ritchson again, this time asking him directly to stop riding so fast through the neighborhood. Video obtained by TMZ shows the encounter turning physical, with Taylor stepping in front of Ritchson's motorcycle as Ritchson attempted to ride away, refusing to move when Ritchson asked him to, and the two men exchanging words before the confrontation became a physical fight. Taylor told TMZ he pushed Ritchson first, and that Ritchson then struck him multiple times, allegedly at least 4 times according to Taylor's own account, an account partially corroborated by video footage that circulated widely once the story broke, showing Ritchson throwing punches while his children reportedly watched from nearby. Taylor shared photos of his injuries with TMZ afterward, describing them to the outlet in fairly graphic terms. The Brentwood Police Department opened an investigation, and on March 24th, just 2 days after the incident, announced that no criminal charges would be filed. The department's determination, based on available evidence including the video footage and witness statements gathered from those who saw the confrontation unfold, was that Ritchson acted in self-defense. That is where the criminal side of this story ends, cleanly and relatively quickly. A 2-day turnaround from incident to a formal declination of charges. A genuinely fast resolution for a case that had already generated significant national media attention by the time the department made its announcement, with outlets ranging from TMZ to Variety to Fox News all covering the story within the same narrow window. Here is where most casual coverage of a story like this stops, and here is exactly where the actual, more interesting legal analysis begins, the part that separates a real legal explainer from a simple recap of what TMZ already reported. A police department declining to press criminal charges is not the same thing as a declaration that no legal wrong occurred, and it does not prevent the other party involved, in this case, Ronnie Taylor, from pursuing a separate civil lawsuit against Ritchson for the exact same incident, even using much of the same underlying evidence the police themselves already reviewed. Multiple attorneys who spoke publicly about this specific case after the criminal investigation closed made this point directly on the record, not as idle speculation, but as informed professional analysis of exactly this fact pattern. Celebrity criminal defense attorney Seth Zuckerman told reporters it is certainly possible Taylor could file a civil lawsuit against Ritchson seeking compensation for medical bills, pain and suffering, and potentially punitive damages despite the criminal investigation's outcome, explaining specifically that the different burden of proof is exactly what keeps that door open even after the criminal door has already closed. Understanding why requires understanding the actual fundamental difference between a criminal case and a civil case, a distinction that matters far beyond just this one celebrity news story, and that shows up constantly in far less high-profile situations that never make headlines at all. A criminal case is the government deciding whether to prosecute someone for a violation of criminal law, and if the government does prosecute, it has to prove guilt beyond a reasonable doubt, the highest standard of proof in American law. Deliberately set high because a criminal conviction can result in someone losing their liberty, their freedom, potentially years of their life. Consequences serious enough that the legal system requires near certainty before imposing them. A civil case is an entirely separate legal action, typically brought by the private individual who claims to have been harmed, seeking money rather than criminal punishment, and it operates under a dramatically lower standard of proof, called preponderance of the evidence, meaning the plaintiff only has to show it is more likely than not. Essentially anything over 50% likely that the defendant is legally responsible, a standard sometimes described informally as tipping the scales just slightly in one direction, compared to the criminal standards requirement of moving those same scales almost entirely to one side before a conviction is proper. These are not just two different processes, they are two different questions entirely. Whether the government can prove guilt to an extremely high standard for the purpose of criminal punishment, versus whether a private individual can show, by a much lower standard, that they are entitled to compensation for harm they suffered. Two questions that can genuinely, legitimately produce two different answers, even when applied to the exact same underlying set of facts. This is exactly why a police department's decision not to press charges tells you almost nothing, by itself, about whether a civil lawsuit would succeed if one is actually filed. The police were applying a completely different standard for a completely different purpose than a civil court would apply if Taylor actually sued, evaluating whether the government could meet its own high burden to justify criminal punishment, not whether Taylor personally suffered a compensable legal wrong under the much lower civil standard. It is entirely possible, legally coherent, and happens regularly in American law, far more often than most people realize, since these quieter civil cases rarely generate the same headlines as a celebrity altercation, for someone to avoid criminal charges entirely while still facing real civil liability for the exact same underlying conduct. Precisely because the bar for a civil finding of liability sits so much lower than the bar for a criminal conviction. This is not a loophole or a quirk in the system. It is a deliberate, long-standing structural feature of how the American legal system separates criminal punishment, which requires near certainty, given what is at stake for the accused, from civil compensation, which only requires a slight tip of the scales given that money, not liberty, is what is actually on the line. Now, let's talk about the actual legal theory a civil lawsuit here would likely rest on, because it is worth understanding in real terms, rather than an abstract reference to getting sued, a phrase that gets thrown around constantly without most people actually understanding what specific legal claim it would involve. A civil claim arising from a physical altercation like this one would typically be framed as assault and battery, two related but technically distinct civil claims that often get treated as a single combined concept in casual conversation, but that actually function as separate legal theories, sometimes pursued together, sometimes independently. Battery generally covers an actual unwanted, harmful, or offensive physical contact, striking someone, in plain terms, the actual physical connection between one person's action and another person's body, without consent and without legal justification. Assault, in the civil law sense, which is meaningfully different from how the word gets used casually or in criminal law where it often refers to the physical contact itself, generally covers putting someone in reasonable fear of imminent harmful contact, even without contact actually occurring at all, meaning a credible, immediate threat can itself be a separate civil wrong, distinct from any punch that eventually lands. Taylor's potential claim would likely allege both: the physical strikes themselves as battery, and possibly the broader confrontation, the moments before contact when a physical fight seemed imminent, as assault, seeking compensation for his claimed injuries, medical expenses, lost wages if applicable, pain and suffering, and other damages a court might recognize as flowing from the incident. Ritchson's own defense in any such civil case would almost certainly center on the same self-defense theory that already persuaded the police not to file criminal charges, since self-defense functions as a legal defense in civil assault and battery claims, just as it does in criminal cases, though again evaluated under civil law's own standards rather than imported directly from the criminal investigation's conclusion, meaning the police department's finding, while relevant and potentially persuasive evidence, would not automatically bind a civil court to the same conclusion. Self-defense as a legal doctrine generally requires that the person claiming it had a reasonable belief that they faced imminent harm and that their response was proportionate to that perceived threat, not an unlimited license to use any level of force in any situation where a confrontation occurs, a distinction that matters enormously in how a jury would eventually be asked to evaluate this specific set of facts if a case actually reached trial. Reports on the incident specifically note that Taylor stepped in front of Ritchson's motorcycle, a moving vehicle, refused to move, and, according to some accounts, pushed Ritchson first before any punches were thrown. Facts that would all be directly relevant to whether Ritchson's response meets the legal standard for self-defense in a civil proceeding, exactly as they were apparently relevant to the police department's own criminal determination just 2 days after the incident occurred. It is also worth noting that Ritchson's children were reportedly present and watching the confrontation unfold, a detail that could support an additional legal theory beyond simple self-defense, defense of others, since a parent generally has an even broader legal justification to use protective force when their own children are nearby during an escalating physical confrontation with an adult stranger, though the exact facts of how directly threatened the children actually were would matter enormously to how strongly that specific theory could be argued. There is one more legal wrinkle worth understanding, because it could genuinely affect any eventual outcome here, even if Taylor does file suit, and it is a concept that shows up constantly in civil injury cases well beyond just this one specific situation. Many states, and it is worth understanding this as a general legal concept even without confirming precisely how Tennessee's own specific rule applies to this exact case, use some version of comparative fault in civil injury cases, meaning if a jury or judge finds the plaintiff himself bears some responsibility for the altercation, stepping in front of a moving motorcycle, refusing to move when asked, initiating physical contact first, any damages awarded can be reduced proportionally to reflect that shared responsibility, or in some jurisdictions, barred entirely if the plaintiff's own fault exceeds a certain threshold, commonly 50% in states that use what is called a modified comparative fault rule. Attorney Zuckerman specifically noted publicly that if Taylor is found partially at fault, which he suggested is a real possibility given the reported facts, any potential compensation Taylor could recover would likely be reduced accordingly, rather than Ritchson simply owing the full amount of whatever damages Taylor might claim. A meaningful qualifier that tempers the sometimes exaggerated headlines suggesting Ritchson faces unlimited financial exposure regardless of how the underlying confrontation actually started or who escalated it at each specific stage. It is also worth understanding what almost certainly happens next in a situation like this, procedurally, since most people have never actually watched a potential civil case develop from a public incident like this one and only ever see the final headline once something is filed or settled. As of this recording, no civil lawsuit has been confirmed as actually filed, only that legal experts consider it a real possibility given the underlying facts and the difference in legal standards we just walked through. If Taylor does pursue a civil claim, it would typically begin with a formal complaint filed in the appropriate Tennessee court, laying out the specific factual allegations and legal theories, battery, possibly assault, and the specific damages being sought, triggering a discovery process where both sides gather evidence, take depositions under oath, exchange documents and any additional video or witness statements, and build their respective cases, a process that generally takes months at minimum before any trial or settlement, meaning even if a lawsuit is eventually filed, any actual resolution is unlikely to happen quickly, and the vast majority of civil cases like this one, involving a relatively contained, single-incident dispute between two private individuals, actually settle before ever reaching a jury, once both sides have a clearer picture of the evidence and the relative strength of their positions through that discovery process. Legal experts specifically noted, in discussing this case publicly, that mutual protective orders are also a realistic possible outcome here, separate from any civil damages lawsuit entirely, since both Ritchson and Taylor could theoretically seek protective orders against each other, given the physical nature of their confrontation. A legal remedy focused on preventing future contact between the two men rather than compensating either one financially for what already happened. This is worth understanding as a genuinely separate track from the civil lawsuit discussion, since a protective order proceeding operates under its own distinct legal standard and serves an entirely different purpose, preventing ongoing or future harm rather than compensating for harm that has already occurred, meaning it is entirely possible for this situation to produce a protective order, a civil lawsuit, both or neither, depending on how each party chooses to proceed and what they are actually trying to accomplish legally. Decisions that remain entirely up to Taylor and Ritchson individually, rather than something the earlier criminal investigation's outcome dictates or forecloses in any direction. Step back and look at what this specific, genuinely newsworthy incident actually teaches about how the American legal system separates criminal and civil liability, a lesson worth understanding regardless of whether you have any interest in celebrity news specifically, since the exact same principle applies to countless less publicized altercations, workplace incidents, car accidents, and disputes between neighbors that never make it anywhere near TMZ or a national news cycle. Being cleared by police, even explicitly on self-defense grounds, is not a legal shield against every possible consequence of a physical altercation. It resolves one specific question: whether the government will pursue criminal punishment under one specific demanding standard of proof designed to protect defendants from wrongful imprisonment. It does not resolve, and was never designed to resolve, the separate question of whether the other party can recover compensation through a civil lawsuit evaluated under a meaningfully lower standard by a completely different legal process, seeking a completely different kind of outcome, money rather than punishment. A distinction that exists precisely because society has decided these two questions, should someone be punished, and should someone be compensated, deserve genuinely different processes with genuinely different burdens of proof attached to them. This distinction matters well beyond celebrity news specifically, and it is worth carrying into how you think about any situation where you hear that someone was not criminally charged for something. That phrase, "no charges filed," tells you the government decided not to pursue criminal punishment, for any number of reasons: insufficient evidence to meet the beyond a reasonable doubt standard, a legitimate self-defense finding, prosecutorial discretion, resource constraints, or simply a judgment call about where to focus limited criminal justice resources. It does not, by itself, tell you whether the underlying conduct was legally blameless in every sense, or whether the person affected by that conduct has no legal recourse whatsoever. Those are genuinely separate questions, evaluated by genuinely separate processes, and conflating them, assuming a lack of criminal charges means a complete legal green light, is exactly the kind of misunderstanding that a case like this one, playing out in public with real attorneys weighing in on the record, helps correct for anyone paying close attention. If this helped you understand a real legal distinction using a genuinely public, well-documented example rather than an abstract hypothetical, hit like so it reaches other people trying to understand how criminal and civil liability actually differ, a distinction that shows up in far more situations in ordinary life than most people ever realize until they are personally involved in one, and subscribe if you have not, because I will cover whether Taylor actually files a civil suit and how it develops if and when that becomes public record. Tell me in the comments whether you had already understood the difference between the criminal and civil burden of proof before this video, because that tells me how much more foundational legal context is worth building into videos like this one going forward, whether that means walking through more real, current examples like this one, or building out a more general explainer on how these two parallel legal tracks actually work side by side.